All right, we got some people popping in here. Let's make sure this chat, while we wait, let's make sure this chat function works. You guys can hear me okay? Just give me a holler on the chat. What's up, Patricia? Thank you for coming. I'm going to, all right, Carmen, I see you. So I don't know where all of you are coming from, probably a variety of different places. But I'm going to share one important resource with you while we're waiting for everybody to join. This is our Facebook group, Indie Fashion Designers and Entrepreneurs. So it's for people like you that are grinding and are hustling and are doing everything in your power to make some shit happen in your life. And I know you probably have jobs, and I know you're doing lots of things. And what we're going to be doing is stuff like this. Things to make sure you guys are killing it. You have the resources, the support, and education. And it's 100% free. And this is a particularly valuable one, in my opinion, because, well, we know attorneys are very expensive. And what we've done is we've gotten one here that is going to talk about protecting your line, protecting you in all the different ways that we're going to learn about, protecting your products, your ideas, and things like that. So this is juicy. I hope you guys are excited. What I want to do also, I just wanted to mention on the Q&A, there should be a little Q&A area right here. As we're talking and you guys have questions related to your specific businesses, or we're explaining something that you don't quite understand, or you just want to ask us something, go ahead and write a question in the Q&A box down here. Actually, if anybody has a question, hit me right now so I can make sure that thing's working. How do I start a fashion line? I hear that a lot. So if you got one, send it in there and keep, yep, there we go. Keep chatting. Yeah, Natalie, shoot me a question in the Q&A, will you? I'm excited to hear from you guys. I'm excited to hear where you are in your process. You know, I want to know everything about what you're working on, how far you are, whether this is just an idea for you, whether you're doing it on the side, or whether you've gone full steam, you quit your job and you're all in. All of that's okay. But the biggest thing that I'm always hearing, it's just you got to be vulnerable in the beginning. You got to start asking questions. You got to be really, really, really serious about making it work. So I want to know all that stuff. We're going to continue to give you guys a lot of content and value on starting the line. So I'll tell, you know, while we got some more people coming in, if you're not familiar with Indie Source, our entire purpose is to help the indie designer, right? So we are here to support those that don't have $1 million in funding, people that are doing it on their own and hustling and trying to make it work. And so essentially we are an extension of your company on the design, the development, and then the manufacturing side. You do not want to jump out of the gate and hire a bunch of sewers before you even know what you're doing. That's not a smart investment. So what we're here for is to make sure that you guys can start the smart way and build your business up without taking on so much risk and so much overhead in the beginning, out of the gate. We are successful if you are successful. That's how it works. And so right now, this is just about giving you guys as much value as possible and allowing you to just take some serious steps towards running your company and making some money. I'm obsessed with sales, and we're going to have a lot more content on that and marketing and branding. But this is interesting because one of the biggest things that I hear from people coming in is, oh, I'm too scared. I have an idea. I'm concerned with telling people about my product. And look, we all know that ideas are kind of overrated, right? So an idea is like thinking about going to the gym. It doesn't matter. It doesn't matter. I'm excited to talk to Ann today, who we have explaining the difference between what you can protect and at what stage you can protect it. And that's something that we're going to get into today, because a lot of people aren't even taking the first step towards the line because they're scared about this idea that they have, right? So we're going to talk a little bit about NDAs, and let me just jump right into it. So who we have here today, let's see, and I'll put up your little info. So, and KEARNS is the founder of KEARNS Law. She has been doing this for 20 years. She focuses on IP, which is intellectual property and commercial litigation and consulting. This includes a broad range of services such as litigating, trademark, and copywriting disputes. This is very important. Negotiating license agreements, which that's a whole basket all by itself, license agreements. Helping startups form their company, which some of you may need support with. She also advises clients about compliance with regulations, including advertising and social media laws. So what can you post? How do you know whether it's okay? Before this webinar started, we were talking about music and what we're actually allowed to put on from other artists that are composing music. So that's super interesting. And then California's Prop 65, which is warnings regarding chemicals and products, including apparel. So some of you guys are making baby clothing. I bet she has some information about that. She is also a business owner. A few years ago, she started her own clothing line, required many hats, including obtaining a manufacturer's license, sourcing raw materials, hiring designers, models, photographers, and engaging in social media marketing. She's been in the trenches of e-commerce, and she knows the ins and outs of starting a business. So she's like perfect for what we're talking about today because she is an entrepreneur. She's worked with us before in the past, and I'm super, super excited to introduce her and kind of get into the weeds on some of this stuff. Thank you, Anne, for joining us, and take it away.
Hi there. I'm so excited to be here. I want to make sure that everyone can hear me. So if I could just have somebody send a note that you can hear me, that would be great. Natalie, if you could do it, that would be great. Okay, perfect.
Oh, yeah.
Great. So I'm so excited to be here, but I'm also really excited that you're here because that means you are serious about figuring out the legalities of protecting your designs. So what I often hear about is that people think that there's just no protection with fashion and that you're free to copy and people are free to copy your designs. And to an extent that's true, but there's a lot of misperception about it because designs can be copyrighted and they can be trademarked. And it's important to know when you can do that. So that's what I'm going to do today is focus on when you can do it and when you can't, because a lot of people out there are copying other designs. Sometimes it's okay, sometimes it's not. So I'm going to take you through the foundations of copyright and trademark law and then specifically apply them to designs. And usually when I do this presentation, I like to make it interactive. So I may ask some questions on what you think. And if you want to join in the chat and just say yay or nay, that would be helpful because it's good to get perspective of where people are at. So with that, I'm going to start my slideshow. Hopefully everybody just sees Anne KEARNS Law Presents. If you don't, let us know. But I'll go ahead and start and have a nice dramatic beginning. Let's get there. Dun, da, da, da. Okay, so here we go, protecting fashion designs. So can you copy this cheerleading outfit? What about Carrie Bradshaw's tulle dress? Iconic. What about Lily Pulitzer's shorts? There's some Jessica Simpson pumps to the left, and we all know Louboutin red sole shoes. What about the Birkin bag on the left? And here we have Brighton Collectibles bracelet. And here we have I think this is Christian Dior jacket. So it might surprise you what you can and cannot copy. You cannot copy that cheerleading outfit, that bracelet, those shorts, the shoe, the Birkin bag, or the coat. You can copy Carrie's tulle skirt and Jessica Simpson's pumps. Why? It seems random when you look at this on what you can and cannot copy. And that's where we have the intersection of intellectual property rights. And there's copyright, trademark, and patent, which I'm going to talk about. There's other sources of intellectual property, but these are the ones that you want to concentrate on and that I'll concentrate on. But we have to start from the beginning and get some foundation on what copyright and trademarks are and patent laws are. So copyrights. Copyright protects things that are that you can physically see and perceive, like books and music and movies, and 2- and 3-dimensional things. What are those? Pictures, graphics, sculptures. A 2-dimensional thing is a picture, a 3-dimensional thing is a sculpture. And the reason that's in red is because it's going to come up later when we talk about fashion design. There are 2 requirements for copyright protection. The first one is that your copyrighted work has to be independently created. What that means is you thought of it yourself. You didn't copy it. It's not already in the public domain. You thought of it, and it's minimally creative. That means it just has this to go over the most minimal bar of creativity. And I have some examples here. The one on the left is the big red dots. That's not very creative. This one on the right is much more creative. So this one on the left, it might meet the minimum creativity standard, but it's going to have very thin copyright protection. This one, on the other hand, has a lot more creativity to it, if you will, and will have stronger protection. The second thing that you need to be copyrighted is it has to be tangible. That means as soon as you take your photograph and it's in your camera, as soon as you put pen to paper, as soon as it's expressed, then it's copyrightable. So what does it give you once you have copyrights? You have 5 exclusive rights. You can copy it, distribute it, make a derivative work. And that means, for example, if I write a Harry Potter book, I have the right to make the movie. I can display it like a movie, and the right to perform it like a play. Registration, this question comes up a lot. Do you have to register your copyright with the Copyright Office? No. As soon as you express your idea, you put pen to paper, you're automatically protected. But if somebody copies you and you don't have a registration, you cannot file suit. You need to have a registered copyright before you can file suit. So a lot of people think, oh, I'll just write a cease and desist letter, tell them to stop copying. But if you don't have a copyright registration, you can't get very far. And copyright registration is really cheap. It's like $35 to $55 per work. So it's worth doing. And then the next question is, of course, do I have to put the little C with the circle? You don't have to do it, but it's recommended because you want to put people on notice that you are claiming an ownership in that copyright. And it also identifies the owner so that if you do have a registration, they can look it up in the copyright database. What you cannot copyright. And this is important because it gets into a lot of gray areas where people misunderstand. You can't copyright ideas. So if I say to Zach, I've got this great idea for a painting. I'm going to have a man walk across the street. Zach can run with it. He can take that idea and express it however he wants. Until I actually paint it and put pen to paper, it has no protection. Same with single words and titles and short phrases. Harry Potter, the title of a book. The actual title in and of itself, not copyrightable. And anything factual, like lists of ingredients or historical facts, not copyrightable. And then last, useful articles. And this one, again, is important. It's in red. Useful articles are not copyrightable. They are considered functional, even if they're aesthetically pleasing or cute. So for example, you see a chair here. It's blue, it's modern, it's cute. You might think it's copyrightable, but it's not because it's considered functional. It's to sit in. Same with the hammer. It's got this cute red handle, but not copyrightable because it's functional. And here's where we get to clothes. Clothes are considered to be useful articles. They warm and cover your body. And when we talk about what's useful about them or features of them that are not copyrightable, we're talking about the shape, the style, the cut, and the dimension. And we'll get into specific examples in a minute. But those are the 4 words that you want to remember when you're trying to decipher if something's a useful article when it relates to clothes: shape, style, cut, and dimension. So let's talk about specific examples of clothes that are not copyrightable. We have a neckline that's considered to be part of a useful article. Carrie's tulle skirt, the shape of it, the layers, again, useful article. That puffy sleeve from Jerry Steinfeld. It's cute, but not protectable. The pant cut, such as being baggy or slim fit, not copyrightable. Your seam type, like a princess seam, not copyrightable. Buttons, the shape of them. Pockets, you have an outside flap there that Kate Middleton's wearing, not copyrightable. And on this prom dress, if you look at the waistband, it's a ribbon. it's very pretty, but it's not copyrightable. So how do we get around this? Well, there is a loophole. The law provides that features of useful articles may be protected if they can be perceived separately and otherwise protected as a work of art. And that's your main test of whether something is copyrightable. So let's look at these cheerleading uniforms. I showed one earlier today. The US Supreme Court took this issue up last year to talk about the copyrightability of designs on clothing. The case is Star Athletica versus Varsity Brands, and it was a big deal in the copyright community, especially fashion law. And what they looked at was whether the stripes, they call these chevrons and stripes, and diagonal lines, whether those were copyrightable on the actual cheerleading uniform. And the court was very careful to talk about whether you could perceive these separately, because that was the main test. And they outlined a little bit of a test. They said, first look at the design and see if you can spot a 2- or 3-dimensional element on that design, that useful article. Let's go back. So here, remember, a 2-dimensional element is like a graphic design. Those are 2-dimensional elements. So once you spot it, you have to see if it can exist on its own. So the test that they usually use is take that 2- or 3-dimensional element and could you put it on a canvas? Could it be a painting? And then could that painting with that line or that chevron stand on its own as its own pictorial, graphic, or sculptural work? And it doesn't matter if you take the lines off and that ruins the cheerleading outfit. The court doesn't care about that. They just want to know if you can take this design and it in and of itself can be protected. And they said, yes, it can be protected. It just has to meet the minimum requirements of creativity. So you cannot copy these designs right here, but you can copy the cut, shape, and dimensions. So I can make a cheerleading uniform that's white, that looks exactly like this. I just can't copy these designs. And so that's the crux of copyright protection in fashion law is, can you take something on a design, separate it out, and protect it by itself? And let's show some more examples. I showed you these Lilly Pulitzer shorts before and said that they were protected. They're protected because the fabric print in and of themselves is protected. I can take the fabric print and imagine it on a canvas like this. So it's protected. The shape and cut of the shorts is not protected, but the design is of the fabric. And Old Navy saw this, learned this the hard way. Old Navy came out with some shorts that looked very similar to Lilly Pulitzer shorts, the fabric design, not the cut, because we don't care about the cut and design, just the fabric. And they came out, Lilly Pulitzer sued, and they settled very quickly. Other things that can be copyrighted on a fashion design, an applique. So here's an ugly, or depending on your view, nice holiday sweater. And here are appliques. I can imagine this flower on a canvas. And same with stitching. I put some unique stitching on these jeans. I can imagine this on a canvas. Shoes. Shoes are similar to clothes. They're considered to be useful. So this shape, cut, and design of this Jessica Simpson pump, there's nothing, I don't see anything 2- or 3-dimensional on here that I could separate out. This has no copyright protection. But this shoe on the right has this surface design. It's almost like fabric. I think those are little sheep. I can imagine that this sheep be put on a canvas and it would meet the minimum requirements. But what about this pom-pom, right? So it's a 2- or 3-dimensional thing. I can spot it. I'm going to take it off and put it over here and look at it. Could it be copyrighted in and of itself? Could it be a sculpture? I don't know. Doesn't look that original to me. Does it meet the minimum requirements? I'm not sure, but something similar is being tested in the courts right now. RIHANNA paired up with PUMA to make these fur slides. I guess they're a big hit, and Forever 21 made a copy of it. And I don't want you to worry about the PUMA words right here because that has to do with trademark. But PUMA claims that this fur strap has copyright protection and that this fur strap is infringing on this one. And what PUMA says specifically is that they claim copyrightable feature is a wide strap decorated with plush fur extending to the base of the sandal. So, and here's where we'll have a little bit of participation. How many people think that this fur strap is capable in and of itself of copyright protection? Could you take this off and could it be a sculpture? It'll fall flat because nothing will be holding it up, so it'll just be on the ground or on the table, so it won't look like this when it comes off. What about all the shoes that came before it? I think my professional opinion is this is a hard sell for them, but they're making the argument. They also make a similar argument. They have a slide that has a bow on it. Again, interesting to see where that goes. Well, looking at the chats, it looks like a lot of people say that there's no copyright. I'd have to agree, but you know, you never know. People, lawyers are savvy in their arguments. My guess is the case is probably going to settle before a court ever decides it. But I am watching that one pretty closely. In fact, I bought the shoe just to see what it would look like. And you know, what I want to do actually is take the first strap off and just see what it looks like by itself, whether it would be a sculpture. All right, so some other things that you can look at that have potential copyright protection. So here's a purse. There's nothing on this purse that I can spot a 2 or 3 dimensional thing that I could take off. So here we have I guess it's a little place to put, I don't know, your water or whatever, but it's just a pocket. And we learned earlier that pockets have no copyright protection. Nothing on here. But here's a purse over here that has all these unique designs. And it doesn't have to be unique, it just has to meet the minimum creativity standard. And I could definitely put this whole thing on a canvas. Belts. Belts can enjoy copyright protection if they have a perceivable 2 or 3 dimensional element. This belt, I don't think so. I had given this presentation to another class before and someone said, well, I don't know, what about this, you know, this square design? Does it meet the minimum requirements? Probably not. But, you know, neither does, in my opinion, the plush fur strap. An argument could be made. But here, of course, there's the ornamental design and the strap also has ornamental design. So this one clearly has protection. This one, very gray to me and probably no. Same with watches. The face of the watch, watches are considered to be useful articles. There's nothing on here that meets the minimum standard for creativity. Here's a watch that has an elephant and an ornate band. So this would get some protection. Unlike watches though, jewelry is not considered a useful article. It's considered to be something that you wear to decorate your body. So it's not a useful article, but you still have to pass the minimum creativity test. The Copyright Office has said that bangles are too simple and there's no creativity in them. So Kate Spade doesn't get copyright protection on this bracelet. BRIGHTON Collectibles though has this very ornate bracelet and I'm sure that they would get copyright protection on it. And in fact, they are claiming that in a case against Macy's. Macy's is selling a somewhat similar bracelet for $550 and against BRIGHTON's $50 bracelet. So again, let's take a poll here. The test for infringement is substantial similarity. So why don't you guys give me your just gut reaction if you think these are substantially similar. It'd be interesting. I got a lot of different answers at my last time I gave this presentation. And I'll tell you what my professional opinion is after seeing a lot of these cases. And you know, these cases go to a jury, so it really depends on people like you in the audience, what they think. My professional opinion is I think they're very, very similar and probably substantially similar. But if you look at them closely, it's possible that they have some differences. It's hard to tell from this picture, but it looks like I'm getting a lot of people saying substantially similar. But also people saying no. And one person says, Macy's looks better. So they made it a better one. So that's my overview on copyrights. It's a lot of information, but your takeaway today on copyrights in the fashion business is the cut and the design and the contours of the shape of a design are not copyrightable, but individual features that you can perceive and separate out, and if they could stand on their own, then those parts of the design are copyrightable. When you go to register the copyright, you don't register the design and the cut and the shape, you register just that feature. And the Copyright Office will ask you specifically, they will exclude the rest of the design. So if I have the cheerleading outfit, for example, I can't copyright the shape and the contour, I can copyright those lines and chevrons. All right, let's go on to trademarks. So basically, unlearn everything that I just told you, or it's going to confuse you, because trademarks are very different from copyrights, and they have a very different purpose, and their test is very different. A trademark identifies the source of the goods or services, and they prevent others from using similar goods. So for example, when you see the trademark Gap, you know instantly it's a clothing company that sells casual clothes, and they're located in various malls. You instantly know the type of clothes and the trustworthiness of that product. A trademark can protect all sorts of things like a brand name, for example, Nike, or a tagline like just do it, or a design logo like the swoosh, and trade dress. And we'll get into trade dress in a minute because that's the one that relates to fashion. There are two requirements for trademarks. The first is that it has to be, you want it to be strong. It has to be fanciful, arbitrary, or suggestive. So for example, Kodak, it's an arbitrary word, it's for film, it's a very strong trademark, but it cannot be descriptive or generic. So this one, PC laptops, they tried for a trademark for the laptops they were selling, and the trademark office said, sorry, we're not going to give it to you because you're describing exactly what you're selling, laptops. The other thing is that they can't be confusingly similar with other trademarks out there. And the trademark office looks at things like whether they're similar in sound, appearance, meaning, or impression, and whether the goods are related. So here's an example, Lila Grace. I think they sold robes. I don't remember the product. Lila Grace versus Lily Grace with a B. The trademark office said too similar, even though this B was an add-on, because Lila Grace and Lily Grace, they both, I think, probably sold robes or something like that, and were considered too close. Similar with copyrights, registration is not required, but it's highly recommended. It will give you nationwide protection. And this is one of the most important things. People really blow off their trademark registration because it's expensive. It's about $300, but it's really important because it'll give you nationwide protection. If you don't have a registration, you're only protected in the geographic area that you're using it or where it's known. So if you're selling in just 2 states and someone from a 3rd state uses it, you don't have very much protection against them. But once you get your registration, you have protection across the whole United States. And if someone uses it in New York City and you're in California, you can stop them with the registration. It allows you to also use that R symbol with a circle, which tells everyone, I own this trademark, back off. And you'll be listed in the United States Patent and Trademark Office database. So when someone's searching because they want their own trademark, they'll see yours and say, oh, someone else has it. So it's really important. It's expensive, but it's important. And that $300 goes a long way. If you don't do it and someone else siphons off all of your customers because they're going to that one, then it was worth the $300 to stop that. Similar with copyright, your notice is not required, but it's, again, highly recommended. If you're registered, you put the R with the circle. If you're not registered, you can use the TM for trademark for goods, or SM for service marks if you have a service. Again, you're putting the public on notice that you are claiming trademark rights in that trademark. And I mentioned trade dress earlier. And trade dress is a little bit different than trademark, but it's within the same family. It's the look and feel of a product, package or design. So, and we'll get to examples in a minute, but to have trade dress, you have to have secondary meaning. That means that consumers out there have to look at your product package or design and say, oh, I know that belongs to XYZ brand. And the package or design can't be functional. So we'll get to examples because those are kind of esoteric. Adidas. We all know the Adidas name. Adidas has its own trademark, the word Adidas, but the shoe itself is considered to have trademark rights under trade dress. Those 3 stripes, when you see somebody wearing that shoe, you probably know it's an Adidas shoe, right? And it's not functional because these stripes aren't meant to hold the shoe together. They're just for looks. And here we have a Louboutin shoe. This red sole right here, everyone knows when Carrie Bradshaw walks down the street with those shoes, we know what shoe it is, or people who need to know. Other examples of trade dress, the Burberry plaid fabric. When you see someone wearing a Burberry coat, you look at the fabric and you know it goes to the brand Burberry. That's a trade dress. Stitching, True Religion stitching. A lot of people know that this U-shaped design on the jeans back here relates to True Religion. That's trade dress. Purses. Here's Birkin. Here's their trade dress, their registration, and they named all of these things, I won't go through them all, as being part of their trade dress. Like there's a padlock and there's a triangle. Every little feature they claimed was protected, and the copyright, or the trademark office did grant them a trademark. So let's talk about the red sole, because this is a great example and people love to talk about the shoe. So Louboutin had this red shoe, everybody knows, with a red sole. And Yves Saint Laurent came up with a red shoe, all of it red. And of course, there was a lawsuit. And so the court focused on, well, first of all, does it have a trademark? It had one registered, but they were going to try to invalidate it. So the court said, well, let's see if they have a trademark. They put the red in the usual place, and now everyone ties that red color to Louboutin. So the trademark, the court said, had gained worldwide recognition, which is that secondary meaning that I was talking about. Do consumers look at that red sole and say, oh, I know the brand? But the court said, and this was interesting, and a lot of people get this wrong in the holding. The court said it's only recognizable when it's contrasted with another color. So if you have a red shoe with a red sole, there's no contrast and there's no infringement. So this shoe was not found to be infringing. So when someone says, oh, the red sole, that has a trade dress, it's the contrasting red sole, and that's important. Here's another example, Gucci. We all know Gucci's color scheme. It's pretty well known. It's green, red, green. So they have an actual trade dress in that, and they have a trade dress in the blue, red, blue. And I'm going to focus on the blue, red, blue, because I think everyone knows about the green, red, green. That seems pretty obvious. But Forever 21 came out with some clothes that had, here's the Gucci and here's the Forever 21. They had the same green, red, green. And then here's the Gucci jacket with the blue, red, blue, and Forever 21 came out with the blue, red, blue ribbing as well. And focusing just on the blue, red, blue, Forever 21 said, Gucci doesn't have a trademark in it because there's no secondary meaning. The public doesn't associate blue, red, blue with Gucci. And how they tried to show that is they went out and in one of their court documents, they listed 130 products that have blue, red, blue. And said, since so many products have it, Gucci can't possibly claim that people associate blue, red, blue just with Gucci. So this case is pending, but I would love to hear from everyone whether they think of Gucci as having a blue, red, blue trademark. My professional opinion is I think green, red, green is easy, but I'm not sure about the blue, red, blue. I'd have to see a little more, I guess, public survey out there. All right, so that is the trademark aspect of it, and I'm going to go over patents really quickly. I'm not a patent lawyer, but I can give you a little bit of an outline for it. So there are design patents that you can get out there. You have to meet certain requirements. It has to be new, original, and have been an ornamental design. It has to be novel, non-functional, and non-obvious. And here are some examples. Jimmy Choo has a shoe out there, and right here, they've got a design patent on this ribbon crossover. And Christian Dior has a patent, design patent on this dress. Design patents aren't particularly great for clothes because they take a long time to get, they're expensive, and fashion usually comes and goes. Fast fashion is here to stay, and unless you have an iconic brand and an iconic product, it doesn't make sense to get a design patent. Some people do it, obviously Jimmy Choo did it, but it's not, I wouldn't recommend it, it's very expensive. Okay, so now what? So knowledge is power. You need to know whether you can copy someone else's designs because a lot of people are out there copying. And it's possible you can, but the features can't be copied. And it's important to do your research whether any design has any registered copyrights or trademarks. And you want to find out what you can protect yourself. So for example, if you have something that's copyrightable or something that has trade dress, register them. That gives you so much protection and so much leverage if somebody steals it. And then, you know, one of the things that we talked about earlier with Zach is, so what about these ideas that I have and how do I protect them? Ideas we talked about are not protectable, but as soon as you express them, as soon as you make your design or write that book, then they have automatic protection. So it's important that you put your ideas down and express them, and then you can get some protection. You can get an NDA. Some factories will sign them, but one of the problems with a non-disclosure agreement, especially with factories who have all of your information, is that factories do a lot of different things at a lot of different times with a lot of different customers. So when you go into a factory, you're going to see all sorts of products, and it's really hard to enforce that NDA or to have the factory enforce it because you go in and it's too difficult. You basically have to have your own factory. And some big companies, they do in-house stuff so that their designs never get out. But the most important thing is to know what you can and cannot copy and what you can and cannot protect, and to take those steps for protection where there is protection. So I've run through this very quickly. There are a lot of things out there that are probably esoteric and hard to grasp, but hopefully I gave you a good foundation, and I'm here to answer some questions.
Thank you, Anne. That was amazing.
Oh, also, one thing to point out is I do give free consultations, 30-minute consultations. You'll get this link in an email tomorrow, but if you need to set up an appointment, you can go to that link, and it's at the beginning of the chat as well.
Awesome. And you can hear me?
I can hear you.
Awesome. Let's do some Q&A real quick. There were a couple of questions that popped up. One person, let's see, had asked, just to clarify, I think I know the answer, but does the material it's made out of matter? Can the material be protected in any way?
Yeah, the material can have a utility patent. It's not going to have a copyright. It's I can't see it having a trade dress.
Mhm.
Maybe, you know, a smell can be trademarked. So I'm not going to say that the material in and of itself can't be trademarked. I'd have to look at that. But certain materials have been known to get a utility patent. For example, water wicking material.
Mhm. Right. Good. Okay. Interesting. All right. So I'm going to go through some of the questions and you can give us your answer. So Dawn asked, I'm almost done with my development stage, ready for samples, and I'm interested in how to protect my line, I guess, before I launch. So I think we've gone through that unless you have anything to add.
Well, really, you know, before you launch, get your trademarks, get them registered. Really important. Of course, you can't register an in-use trademark registration. You have to actually be using it, but the trademark office allows you to register intent to use. So even if you haven't launched and nobody knows your name, you can still register it as an intent to use and it reserves the name. So important step for you to take. Now, one thing about the trade dress, remember we said for trade dress, like those purses, the Birkin purse, you have to have secondary meaning, which means the customer has to recognize it. And often that takes a couple years and a lot of press. So you can't put a purse out and then tomorrow say, I got trade dress in this. It takes some time to build up that secondary meaning.
Right. Okay. She also asked, I plan on purchasing my own print. Can I copyright that?
Yes. Okay. So here's an interesting question about fabric print. I can't go to a retail store, a fabric store, take the print, make it, and then copyright that print because it's not my print. The person who owns the copyright to that print is the manufacturer of that print. If you want to go all out, you could make your own print, like Lilly Pulitzer. I'm sure they have, you know, in-house designers for their print because that's the print is their business. Make your own print, and then you can copyright it.
Got it. Okay. So let's see. Deborah asked, do you need separate trademarks for designs as well as slogans? So the slogans covered.
You got to do a trademark for every single one that you have. So if you have a name like Nike, if you have a slogan, just do it. If you have a logo like the swoosh, those are 3 separate trademarks. And then if you have trade dress, which is the product design or packaging, that's its own. So every single one has its own trademark registration.
Got it. Cool. Okay. Danit asks about an NDA. Do you have a recommended template or for international manufacturing, how does the material presented today apply if we're producing abroad, overseas?
Okay, well, the first question was the NDA template. There are NDAs on the web. I personally, you know, I think they're okay. There's for example, there's a lot of stuff missing. Different states have different requirements, but you can find them if you have to. And then, of course, it's whether you can get the factory to sign them. That's often difficult to do. Sometimes you can get your pattern makers to sign them. That's actually the place that I would start, is a pattern maker, because they're the ones who can, they're the ones who have all the information. A factory has that information, but there's really not much you can do because there's so many different clients in the factory. Okay, what was your second question about the international? I guess I didn't hear it.
That second question was, how can they protect themselves if they're going to be manufacturing abroad?
That's tough. It is really tough. You set yourself up for vulnerability when you manufacture abroad, because China, for example, they have protections, but it's very difficult to enforce. You have to be able to enforce in the United States, and having jurisdiction over those companies is very difficult. Good luck.
Another reason to produce in America.
No, it's a great reason to produce in America. You know, I know a lot of people they see prints over in China or wherever, they copy them, right? And they bring them to the US. And that's risky business because, and especially if those prints are used for bigger retailers, they will come after you.
Cool. Someone had asked, what about thumb holes that are added to sleeves? Can they be patented or copy marked?
So no, the hole itself, it can't be copyrighted because you can't take that hole and perceive it separately, right? That's the test. Can it be trademarked? Well, it's functional. It cannot be functional. The hole is functional for your thumb. Could you have a design patent? No, because it's functional. Could you have a utility patent? I don't think so, because it's a pretty obvious thing, but I'm not a patent attorney, so I can't speak to that, but no copyright or trademark as far as I can tell.
Got it. Got it. Good question, guys. These are amazing. Keep them coming. So we have another one about, you were talking about dyes not to put in clothing for babies. Oh, I don't think we brought that up. Dyes or that was part of the initial slide, I think. Yeah.
Yeah. So I'll just say really quickly about Proposition 65. This isn't really necessarily towards baby clothes or not, but one thing designers don't know about, and that they need to start really figuring this out because they get into big trouble. California has a law called Proposition 65. And what it says is if that you have one of 900 chemicals, which is basically every chemical, if you have some amount of that chemical in your product and you sell it to consumers in California, you are governed by Proposition 65 and you have to provide a warning notice on your product. The one loophole is if you are a company that's under 10 employees. Okay, so I have my own clothing business and it's just me. So even if I made lead sleeves, I don't have to put a warning on it because I'm under 10 employees. However, and here's the big problem for designers, if they have any intention of selling to a retailer, so they're in essence a distributor or a wholesaler, they make their designs, they sell it to a shop. If that shop has 10 employees and they're governed under Proposition 65, that shop is going to want to make sure that all of their clothing, they know the chemicals in them. And if a warning is required, you're going to have to tell them.
Right.
So even if you're under 10 employees, you're like, oh, Prop 65, that doesn't matter. It can matter if you're going to sell not directly to the consumer. And the penalties are awfully stiff. You will be paying thousands of dollars. And once you're caught, you're caught. There's no, I'm just a small guy, it doesn't matter.
Great advice. Good question, Chris. A lot of these designers are selling direct, but like it needs to be considered. That's an awesome question. Let's see, what other questions do we have here? Will the slides be available via PDF? Yes, we can share those with you guys after this is over. If we sell on Amazon, is that considered a larger retailer?
Yeah, so it's interesting.
Yeah.
Selling through Amazon, right? So Amazon is the distributor. I believe that, yes, if you're selling, like I sell my clothes on Amazon, it's direct. So I'm the shipper.
Right. They're a distributor rather than retail. Right. Great question. Are RN numbers necessary on all labels?
Yeah, no, you have to have something, okay? So you have to have either the RN number or you have to have the manufacturer name. So the rule is
right.
Open-ended that you can do one or the other. A lot of people do the RN number because it's easier, or they don't want to show the manufacturing name because it's in China or wherever.
Got it. A lot of questions here. I'm just going through all these. Materials are repurposed. How does Prop 6? So yeah, guys, we're going to send a follow-up email tomorrow with a little, with the recording, with the freebie. There's also just kind of like a checklist for you guys to go through. And I'm going to share the link with you right now. Do take advantage of this. I have never met an attorney that would give me 30 minutes like this. So take advantage of this if this is something that you're serious about. I mean, please don't waste our time. But if you guys have some specific questions about where you're at in the process, and if the things that you're working on can be, and should be protected, then take advantage and just use the Calendly link to get on her schedule. So that I just put in the chat the checklist. So you have that. You have the Calendly, and then anything else, Anne?
Nope. Make sure you mention when you call that you are on this.
Just put your phone number in there, put your information, and then just mention that you were listening to the webinar. Again, I threw in the Facebook group for you guys. We want to continue to hear about where your blocks are, right? We understand that you're hustling and there's a lot going on, but I want to know the immediate thing that is impacting you from achieving your goals, okay? So if you're not on the Facebook group, I just put it in the chat. Indie fashion designers and entrepreneurs, join us or hit us up on Instagram or Facebook or whatever, but keep us in the loop about where you're at, and we're going to continue to provide experts like this, like Anne, and we appreciate you guys taking your time out of the day. Contact me if you have any questions, and sign up for this thing, and let's get this thing going. Thank you, Anne, so much. This was really, really valuable. I learned a ton, and this is exactly what they need. Remember, ideas are nothing, so get your ideas out of your brain, write them down, talk to people, and actually start building your line, okay? Thank you guys for being here, and good luck. We'll talk soon.